going to look at the lawsuit filed by Gabby Petito's parents against the parents of Brian Laundrie, who murdered Gabby. You probably know this case and remember that last year in August, late August, she was murdered by Brian after going missing after an encounter with police at Moab in Arches National Park. That case came on the heels of 2 other women being murdered near Moab, and also happened to be the time when I was in Moab and at Arches shortly after that, before Gabby's body was found. So we were watching this case pretty carefully while we were out there. Also, when we came back and he was allegedly missing, at certain points he was reported to be in North Carolina near where we are. So we kept an eye on that, also hoping that she would be found. Not as it concluded that she was murdered, the worst possible outcome, but she was found at least eventually, and that gave something to her parents. And Brian did maybe the best thing that he could ever do in his life, the only worthwhile thing he could do, in my opinion. Sorry if it offends you, but he killed himself. So he took himself out of the equation and ended that. But in doing that, the other thing he did was leave no one directly responsible for the murder available to be accountable for that. So his parents, of course, took various actions in this when he returned home. Depending on where you stand on it, you really don't like him, or you think it's excusable because it was their son and they were trying to help him. I fall on the side of they crossed from trying to help their son to becoming absolutely disgusting. That's my personal opinion of this. At any rate, they're the ones alive and left involved in this, and so the parents of Gabby have filed a civil lawsuit against Brian's parents for intentional infliction of emotional distress. And you can see in the hearings the way that they're looking over at the other side, the anger that they feel at the loss of the daughter. Gabby is completely focused on the people who remain alive at this point, and it's understandable. But we'll look at the lawsuit that was filed, the quality of that lawsuit, the motion to dismiss that was the response of Laundrie's parents, and whether that had merit or not, what the judge did with it, why he did it, and what's going to happen with this case going forward. So the complaint you see here is by both parents of Gabby against both parents of Brian. As we talked about in other videos, you see in the normal practice of a lawsuit, the complaint, the first pleading, there's usually predicate matters covered, which is the parties, where they reside, to indicate a jurisdiction, venue, usually a factual narrative. Okay, here's what we say happened that we think matters. Then as you get further into the complaint, you will see the actual legal theories that are presented. Count 1 or cause of action 1. Normally that's alleged out and the elements of those, and then you get to the bottom with a prayer for relief. Because every complaint has to have at least one legal claim in it that is a valid, recognizable theory of relief, that the court can say, if these things are met, I will grant you the relief that you're asking, money or whatever. So this complaint was filed, but as you see through the pages I'm showing here, it never says what the cause of action is, or in particular what the elements are. That's abnormal and not normal from what you see in a complaint. The practice is to set those things out specifically, because they are technically required, or your lawsuit is subject to dismissal. Now, it's not technically required that you present them the way I've described, which is count 1, count 2, or whatever. It just has to be in the complaint in a way that meets the elements that are required under the law. It's not a specific way that it has to be pled. The law is not supposed to be that technical. So there was defenses raised to this, and I think there was an indication, even perhaps by the judge, that this thing may get thrown out. So they filed an amended complaint. They show that here, and you'll see it's got some more facts alleged in it, some different facts alleged in it. It sets out specifically kind of what the alleged outrageous behavior is. It still doesn't set out a particular cause of action, but it is improved over the first complaint. And nevertheless, it was subject to a revised or amended motion to dismiss by Laundrie's parents, and that had some good arguments in it. So we'll go over what the case is and what the arguments against it are, and where the judge came down on this. Ultimately, at the hearing, the motion to dismiss was argued on the basis that this complaint was one for intentional infliction of emotional distress, and the court noted that the elements required to be pled to sustain that cause of action are these: deliberate or reckless infliction of mental suffering, that's first; outrageous conduct, the conduct caused emotional distress, and the distress was severe. So it goes on further to note, of course, that it can't just be something mean or pretty bad or whatever. The behavior claimed to constitute this must be so outrageous in character, so extreme in degree, go beyond all possible bounds of decency. The subjective response of a person to that, like they personally got very upset, that doesn't control whether this element is met or not. The court evaluates the conduct objectively and says, is this so atrocious, so utterly intolerable that we will not allow this in a civilized community? So that's basically what you have to set out in your lawsuit if you don't want it thrown out, if you're trying to sue for intentional infliction of emotional distress. So Laundrie's parents filed a motion to dismiss, saying, among other things, you didn't set all these things out. And the things that you did set out either don't rise to this level as a matter of law, that in other words, even if it were true in the complaint, it's not going to meet this element, or the things you set out are protected by law as a matter of law. So there are no fact issues existing on the basis of the complaint that you filed, that even if everything you said in the complaint were true, which is how the court will take a motion to dismiss, it still would not be enough to sustain a verdict on this count. The first argument by Laundrie, or at least the shot they take at the complaint, is that it does not say in it that there was intentional infliction of emotional distress, leaving the defendant guessing which cause of action was meant to be alleged here. That's a nice way to start out. It's not dispositive. I'm not going to get a ruling based on that, but it does point out that we all have to go hunting to figure out exactly what is the legal theory of relief claimed here. So the better course, I think, in filing obviously a complaint, and what you're going to see in almost every other one, is the cause of action will be titled and the elements will be set out. And that way you're essentially immune from this, what are we even doing here kind of a thing, argument that they're making, which is a fair argument. You don't want, if you're the plaintiff, the judge to have to hunt through it to find all the elements that you're alleging to say, yeah, you did it, you got across the finish line. You want that to be very clear. You don't want to have any chance of falling short of that at this early stage of the lawsuit. But beyond that, because while that's a technical argument, if in fact the elements are in the lawsuit, the judge is going to allow it to continue. So they have to address whether those things occur or not. So the first good argument they make beyond that is that the inaction by these parents, that's not outrageous conduct, and it also is constitutionally protected. Remembering back just a minute ago to the elements of intentional infliction of emotional distress, the conduct has to be so outrageous, etc. So that mere inaction or refusal to talk to somebody, blocking them on Facebook as alleged, or blocking their number, it is hard to see how that could be on its own outrageous conduct or essentially action at all. They're just, I'm not going to tell you anything. Pretty good argument by the defense on this. They also make another argument that, well, the letter that was given out, which is an action by them that their attorney put out, the parents of Brian Laundrie, saying that they hope the search is successful and hope that Gabby is reunited with her family. That's an action that was taken. His attorneys, or the parents' attorneys, say that wasn't directed to Gabby's parents, and therefore it just went out to everybody, so it's not something that was directed to them, and for technical reasons that wouldn't count under this. And to support it, they cite some things, but they put in what I think is just an absolutely horrific, horrible sentence in their brief. I don't know how somebody could write this. I ain't going to show it to you here. In support of their argument, they go on and carry on and say, what happened to Miss Petito is certainly unfortunate. However, etc. There's no however after that. It would have been unfortunate if Gabby's hotel reservation had been canceled, if it had rained while she was planning to hike, if she stubbed her foot or whatever. She was brutally murdered and left to rot while the murderer and his family refused to say where her body was. That's not unfortunate. That's horrible. That's a tragedy. I don't know how the attorney could write what he wrote here. The judge didn't, I don't think, harped on that or whatever, but it certainly caught me in reading this. Like, I do have some emotional connection to this case, and to see somebody write something like this, it's personally offensive to me. So I wanted to point it out to you. So we'll move on to their next arguments. Defendants argue that there's no causation alleged in the complaint sufficient enough to sustain the complaint, or severity of emotional distress. So the causation piece is basically saying, hey, nothing we didn't do, in other words, we didn't say to you where her body was if we did know, which we say we don't know, or that we actually did do, put out this hope that she would be reunited with you. Those things were not the cause of the emotional distress that you suffered. The cause of that was the fact that she was missing, that you didn't know where she was. That's the thing about that. The well wish that we put out there that, hey, I hope she's found or whatever, that didn't cause your distress. At least you didn't show how it became a separate factor of distress, a separate level of distress, or a sole and proximate cause of your distress. We'll see how the judge dealt with that in a minute. Then they also to go on to this, goes back to this situation I mentioned a moment ago about how they wrote in there that it was unfortunate that she was brutally murdered. Yeah, that's unfortunate. The complaint alleges, the defendants say, the plaintiffs were, quote, extremely distraught, end quote, desperately searching for information concerning their daughter. It does not specifically discuss how the plaintiff's mental suffering meets the severity element, or does it describe their distress as severe. And then they go on to quote a case. It says, the fact remains that significant feelings of fright, shame, worry, and humiliation, and others besides, occasioned by the acts of others, even if regrettable, it's an unavoidable part of living in society, end quote. No. Sorry. Is there any empathy on the defense side at all for the fact that these people's daughter was brutally murdered? This is just part of living in a society. If the family hides the fact that your daughter's murdered, issues out a statement that implies a falsehood that she's still out there and could be reunited with her family, prolonging the suffering that you have. That's just something that happens in society. To me, a stunning tone deafness in this brief. Not saying the attorney meant to do it that way, but I certainly would never write a brief like this. I don't know how you can understand the facts of the case and that this young woman was murdered and left to rot outside, and not have a tone of empathy come through in the pleadings and the arguments that you make. That doesn't hurt your clients to show some level of humanity, and I don't see it here. So again, that's personal opinion. Sorry, I usually try and be objective, but I don't like it. The court notes first, appropriately, this is a motion to dismiss. So the court is going to take the facts alleged in the complaint as true. It's not going to consider other things. That would be a summary judgment motion if one comes later. And see whether the complaint itself sets out enough facts to sustain at least one legal theory that is recognized as a claim for relief. And if it does, the claim will survive. That's how a motion to dismiss works, and typically on a 12b6 kind of motion. Failure to state a claim upon which relief can be granted. Now, the judge notes first off that even plaintiff's counsel struggled with the concept that the Laundries had any duty to act to reveal information. I watched that part of the hearing, and the lawyer was very candid with the court, which I appreciate, saying that he struggled to say that was a legal duty, which is essentially admitting it isn't. And the court says here that if this case were about the silence of the Laundries, whether you find that detestable or not on a personal basis, if it were about their silence, then he would throw this case out. But he notes in a paragraph of one sentence, they did not stay silent. The court then moves to the statement made by Laundrie's parents, and I'm going to quote him here because this is the whole lawsuit in a nutshell. Without it, there is no lawsuit. The Laundries contend that their statement is not outrageous as a matter of law. At oral argument, they suggested it merely was a plain statement. Plaintiffs, in contrast, countered during oral argument that the statement knowingly was false, designed to create false hope, and issued by the Laundries who knew Gabby was dead and where her body was located. So the Laundries had argued that the one operative action in this case, the statement that they made, it's not an offensive statement. It's not that outrageous on its face to meet this high level that the law demands to state a claim for intentional infliction of emotional distress. The main part being, on behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. It's not outrageous. That's just well-wishing. Everybody was searching for her. That search was ongoing before they said that, and it was ongoing after they said that. It's not outrageous. Throw this case out. But the judge cites cases that says, I can look at context, the context of that statement. By itself, it's not outrageous. However, as alleged by the plaintiff, the judge notes, they made that statement knowing that Gabby was dead, knowing the location of her body, and knowing that her parents were frantically looking for her. If this is true, and remember, it's going to be assumed to be true for purposes of motion to dismiss whether it is true or not, then the Laundrie statement was particularly callous and cruel, and it is sufficiently outrageous to state claims for intentional infliction of emotional distress. So the judge ends up denying this motion to dismiss based on this statement, saying that if you read this complaint, You look at what they said, seems innocuous when they said it. However, if they had this other knowledge, it was far from innocuous. It was calculated to make themselves look good, buy more time. And in doing that, it increased callously, recklessly, intentionally the suffering that Gabby's parents were enduring. And given that was the only statement they did make because they blocked her mother from contacting them in other ways, that's all they had to go on was this statement. And if you read it fairly, it implies that we think she's still alive out there and we hope she'll be reunited. But they say in the complaint, and I certainly buy it at this standpoint from what I've seen and just my personal belief, not evidence, that they knew that she was dead. They knew their son was responsible. They were trying to figure out how to handle this, and they issued this statement. They should have just stayed shut up or said something like, this is a terrible situation, we're praying for everybody. Instead, they issued this statement that the plaintiffs say was intentionally misleading, and now they're facing this lawsuit. So it gets past the motion to dismiss. What happens next obviously goes potentially into discovery. They exchange information, evidence, find out more about each other's case. That could cause a motion for summary judgment to occur. Maybe not, probably so though. If they survive that, then it would go to trial. So the case is passed the motion to dismiss. We'll see what comes up with it. It's not a complicated case. It really turns on, are they going to be able to show evidence that the parents of Brian Laundrie had reason to know or did know that Gabby was dead or something like that, that harm had come to her, and so that this statement they released when they released it was misleading and intentionally misleading, amplifying the severe emotional distress that her parents were feeling. That isn't going to take too long, I suppose. It's just a question of whether that's actually a fact and whether they're going to be able to prove that or not. So this case is quite simple, and it comes down to how people feel about the statement they made and what their frame of mind and knowledge they had when they made the statement. Those are the two things in operation in this lawsuit. So we'll see what happens with it. It doesn't bother me that they're going through it because I think they were callous toward the parents of Gabby. And it's unfortunate, and I hate it for them that they lost their son. But they did more than that. They, in my opinion, took steps that caused emotional harm to other people, and they didn't need to be handled that way. That was their choice. Now there's some kind of consequence for that. Thanks.